I'm trying to get everybody logged on. We got problems. I was just on a big call.
Hi, Patty. How are you?
Hi, everybody. I'm sorry I'm late.
No, thank you for being here for us.
Thank you for being
No,
here.
you guys don't even know. We got big problems. We got to talk about them. That's why I was gone. Just hang on. Let me try to get everybody in here. Why does it? Oh, it says you're coming. Okay, yay. 2 people entered the waiting room. Admit all. We got 2 people trying to get on that just can't. All right. Hello, everybody. Hi, how are you? Sorry I'm late.
Hi.
I got out of the shower, let my hair dry, and then I've spent a very important conversation on the phone with some very important people. So forgive me. Oh, we're in my back room today. I don't care. It's a mess. Hi, everybody. So I have things I want to talk to you guys about, and I'm about to write an article on this. It's been happening for a couple of years, and we didn't know why. Guess who figured out why? You know how we've been going to court, and attorneys have been telling us you got to remove your rent increase from your ledger? We're like, huh? Why? And we're going to court for an eviction, and pay attention here, you guys, because this is the problem. You're going to court for an eviction, and the attorney says you must remove your, hang on, and I'll think about this for a hot second. You must remove your
late fees, right?
No, not your late fees, your rent increases. How many of you have heard that you have to remove your rent increase? Ha, now I feel better because there's a background behind me. Sorry. I don't have to worry about if my grandson pops his head up or one of the cats or the dog. Oh my goodness, did you guys see my dog? Okay, lots of information to give you. I know I'm all over the place. Okay. A lot of times when we go to court, the attorneys are telling us to remove our late fees, especially in LA. Let me tell you why. And I'm about to write a big article about it. The reason that they're so particular about your late fees is a lot of us aren't following the rules. What do you mean, Patty? What are you talking about? If we give somebody a 30-day notice of rent increase, and we just mail them certified mail, so we have that certificate of mailing saying that we did it 30 days in advance and we want that rent increase to take effect in 30 days. Okay, a lot of us do that. If we didn't allow 5 days for mailing, the rent increase is invalid, and so is every rent increase after that.
Say that one more time.
Yeah, say that again.
Yeah, say that one more time because I just didn't hear that right. But Patty, enlighten me.
When we mail a notification, we have to add 5 days for mailing. So that 30-day rent increase notice takes effect in 35 days, not in 30.
What if I posted it on the door and mailed it?
Hold on, just pay attention. I'm talking about straight mailing the notice.
Okay.
Okay? Post and mail, different set of facts. A lot of people just send it certified mail 30 days in advance, but it doesn't take effect for 35 days because we have to allow 5 days for mailing when we mail a notice. A lot of us have a lot of illegal rent increases because of that. So here's what I want you guys to start doing to help you, okay? Instead of doing a 30-day notice of a rent increase, make it 45 days. Instead of doing a 90-day increase, do a 100-day increase. Humor me. Okay? That's what we're going to do going forward is we're going to give more than 30 days. Fair enough. We can give more than 30 days and be fine. If we give less than 30 days, we're in trouble. If we only mail it, we have to add 5 days to that. Okay, everybody's got that picture painted broadly, right? Because I'll tell you right now, it's the first thing opposing counsel's looking at. So was it a 30-day increase or a 35-day increase? Because if you raise rent before 36 days, you're in violation. It's an illegal rent increase. And they're going back decades. Look at it this way. If 10 years ago you did an illegal rent increase because you only gave them 31 days and you mailed it, then every rent increase after that is also illegal. Okay? Deep breath. Deep breath.
What if you give it to them in person? Like
Then it's
before?
personal service, not mailing.
Okay.
I'm talking about mailing, and where mailing gets you in trouble because you have to add 5 days. Is it that an illegal's rent, hold on, let me reread this, Julia. Whew. Is it that an illegal's rent increase, an illegal rent increase, or you just can't add late fee until the 5 days have been met? No, you're not paying attention.
Sorry, and I put illegals. I'm going to edit it. I meant illegal.
No, you're
S.
fine.
I
If
was
it's
trying
an
to edit.
illegal rent, is it that it's an illegal rent increase? If you didn't allow 5 days for mailing and you increase the rent in less than 36 days, you violated California's civil process.
Yeah, so let's say you're a day short. Can't you just say, can't it still be in effect, but obviously you just don't charge them that late fee? Like, can't it be, so let's say, everyone wants rent on the first of the month, so July 1st. Let's say it doesn't kick in until technically the full 5 days, let's say July 2nd. So can't from the second they're on, and technically if your late fee is that it's late on the 2nd,
If
well,
you
then
want
obviously
to
don't
raise
charge
rent,
them.
hold on. If you want to raise rent for July 1st and you mailed the notice on June 1st, you messed up.
I guess I was thinking, well, you mess up once you charge them the late fee, not that you mess up.
No, you didn't give them the rent increase. So it would take effect the following month in August on the 1st.
Could it
because
ever
wasn't
take,
a full 30 days.
can't an attorney argue that it would take effect, okay, come July 6th or July 5th?
Okay, it comes effect July 5th. When's the rent due? July 1st? Because that's how much the rent is. It didn't increase until July 6th. And do we pay prorated rent in mid-tenancy? No. So the rent increase would then take effect on August 1, not in July.
Okay, got it.
So what I'm telling you guys is when you're counting a 30-day notice, because I now know this is what opposing counsel is coming at you for, okay? So if you know what they're going to look for, beat them to the punch. Instead of doing your 30-day notices and wanting the rent increase in that 30 days, in your brain, do it for 45. Give them at least 45 days of a notice of rent increase. Example, I want to raise the rent, what is this, July right now? September 1st, I'm going to serve the notice today. I'm giving 45 days notice. I'm giving more than enough time. Make sense? I want you to start doing it that way and not be on that quick 30 days. Give more time, okay? Even if it's 15 days more, it doesn't matter. Rent's due on the 1st. We're not going to prorate it. If the rent increase takes effect mid-month, no, it takes effect when the rent is due. So it would be effect the following month. So just try to give yourselves more of a cushion there now that I know how they're attacking you. Okay, there's things they're doing. They're looking at your rent increases. They're looking at late fees. Your attorney will tell you to remove your late fees from your ledger because they don't want to open up that argument. Yeah, it's still owed to you. We just don't want to argue it in this courthouse. We'll argue that in a different court later down the road. Small claims out of the security deposit, okay? Not an eviction trial. Okay, when you're going to eviction for non-payment of rent, you have to make sure your ducks are in a row in LA County like nobody's business. And if you're in the city of LA, you need more than ducks. You need swans with you.
So you can't have late fees ever? Because that late fee thing is like something new, right?
No, let me explain something to you. This is Susan, right? Just so I know who I'm talking to.
Oh, yeah. Sorry, Patty. Yeah.
No,
Susan.
no, it's fine. You guys, I'm guessing here. If I'm wrong, you shoot me, okay? It's been one of those weeks. Okay, late fees. Let's talk about them. I'm going to assume that your rent is $3,000, okay? Just play along, Susan. and your late fee is 10% of the rent. So your late fee is $300, okay? Only on your mortgage, your late fee is $35, isn't it? Isn't it?
Yeah.
Okay, with that said, right there, if you collect the $300, are you making a secret profit?
Huh.
Oh, real estate agents and brokers cannot do that. Okay? So this is what's being argued right now, and it's being heavily argued until they come up with how it's going to be looked at in a court of law. We don't want to introduce the argument into your court case. I say we. I'm not with a legal team anymore. Your attorney doesn't want to introduce, we don't want to knock on the door and say, hey, poke me in the eye right here. So we just want to remove the argument from your ledger. That's why they're asking you for a handwritten column or ledger, so that it just shows rent and rent payments and nothing else. They don't want it showing rent increases or late fees unless those rent increases. That's why they want to see the notice. How was this served? I mean, this is to the point where they're deep diving into evictions, and I just saw an eviction go through. Okay. Well, it didn't go through. They lost. They ended up having to refund 10 years of illegal rent increases because the one they did at year 10 ago, actually, I think it was year 11 ago, was illegal. That way, every rent increase after that was illegal. So add up 10 years of rent increases, the tenant doesn't owe rent. The argument for late fees is something that I don't even want to touch because it's so argumentative. Okay? Because we would argue, I'm going to argue, okay? I'm sorry, I use my late fee as a deterrent so that they pay the rent on time. Late fee is a deterrent for timely rent. Until you collect it, then what is it? Ugh. So I'm not telling you don't collect late fees. I'm not telling you don't charge late fees. But here's what I will tell you. If your tenant's paying you a late fee, collect it. If you want to enforce a late fee, you could serve the notice, but I don't necessarily say that I'd start an eviction because the tenants aren't paying late fees. You're probably going to lose unless it's outside of LA County. And as far as other counties, it's still questionable, because they will make you remove your late fees in every county because they don't want to argue it, and that's why. Is it secret profit? Is it price gouging? It's not equal. Oh, yeah. What about the fact that it messes up our credit? They don't care. Okay? It's still being argued, and we want to stay away from it. Okay? We want to stay away from it. Somebody is texting me like crazy. I apologize.
So even if it's in the lease that the tenant signs that if rent is due on the 1st and they don't pay it by the 3rd, I impose late fees. I cannot,
Correct.
and I'm not evicting them based on the late fee, but just the rent. But they paid late fees in the past. Can they use
If
that?
they pay you a late fee when they pay their rent late, accept it and say thank you.
But on the ledger, what I'm saying, so like now I'm evicting a
Leave
tenant.
it all on there. If you're going to trial, your attorney is going to tell you what to do. And 9 times out of 10, 9.9% of the time, they want you to write a handwritten column or ledger, which basically says rent January $9.95, rent paid $9.95, February rent $9.95, rent paid $4.95. Ooh, we're $500 short. Pay attention. Rent March $9.95, balance due $14.95 because they owe us $500, right?
Yeah.
That's all they want to see. They don't want to see late fees. And that's why it creates a huge argument. Are you price gouging? Are you making secret profit? What are you doing? Blah, blah, blah. That's not what the bank charges you. That's not right. Just because you put it in your lease doesn't make it legal. So,
oh my God.
Right. You guys hear all the argument? Just stay away from it. And that's not the place to go after your late fees. Okay? When they vacate, take it out of the security deposit, and that still becomes questionable. If they have 1 or 2 late fees on there, I would contemplate not, and they're getting their whole deposit back except for 1 or 2 late fees. I'd probably waive the 1 or 2 late fees. Or, and I know Chris is going to say this is a better practice, go ahead and charge it. If they argue, then you can revise and refund to them.
Or, I mean, it depends what your late fee is, like realistically speaking.
Well, I'm talking about
This isn't legal
200
advice. This isn't
No.
legal advice. This
No.
is business advice. But if you have like a $25 late fee because, you know, a very small little late fee because you just want to encourage people to pay their rent on time, and they, let's say twice they were late and you noted it, and you take $50 out at the end. I mean, the likelihood. Now, if there's tons of other stuff they're going to litigate over because they've you know left the place a mess. There's lots of damage that's not beyond ordinary wear and tear, and you know it's going to get into it. I mean, it can also be leverage of something to give back. But if not, if it's a couple times they did that, so it's like $50 or something, like who's really going to take the time to go after you in small claims over $50?
Exactly. If
not
you
to-
have $1,700 of late fees, that's a whole different scenario.
But even then, like, you know, I've had questionable situations.
All right, but
There've been questionable situations where people don't want to. Some people are not going to fight over, you know, $1,500 in a questionable situation,
especially if they left the state. That would be very inconvenient for them.
right? Or even left the jurisdiction. I mean, the Bay Area versus here, you know.
Yeah, absolutely. So it's on a case-by-case basis, just like the rest of property management. But all I'm
Right,
telling
and it's
you
a business
guys,
decision.
it's a business decision. Eviction courts aren't where you want to argue your late fees. Oh, hang on. Hi, Patty. I did that. That is what I text you about with a different dilemma. I mailed the Modus first class certified letter with no signature, return receipt with all required enclosures, tenant's rights notice, the added right to counsel, on June 25th for a rent increase to be effect on August 1st. The problem is the tenant wasn't home on June 28th, and the notice for redelivery or pickup at the post office was given by the mailman. They have not gone to pick it up or plan to. If they do not pick up the letter or reschedule delivery by July 12th, it will be returned. Honey, as much as I could tell you this, just go serve it on their door. Hire a process server. And just have them go serve the notice. And then you're not having to worry about that certified mail signature and all that garbage. Process server needs to fill out a proof of service. You can serve it yourself and fill out a proof of service, but personal service is what you want to do. It's the best way to serve somebody. You've been served. Here you go. Have a nice day. Enjoy your weekend. Remember, when it comes to serving documents, there's 3 ways, and only 3 ways to serve them. So pay attention, okay? It's on your proof of service form. 1 is personal service, meaning you handed it to them. Here you go. Got it? That's personal service. Number 2 is subservice, and it is the worst service out there, in my opinion, because 9 times out of 10, the person you hand the notice to isn't a legal adult. Can't hand that to a minor. And 9 times out of 10, when you get to court, that guy with the beard isn't a guy with the beard, it's a 16-year-old. Hi, it happens. Okay? With that being said, I hate subservice, because that's what they call it. Personal service is the best. Subservice creates an argument. The third option you have is post and mail, which means you tape it in a conspicuous place on the property and mail a copy first class mail the same day. If you post and mail on a Sunday, did you post and mail on a Sunday? Yeah. How did you mail it on Sunday? It's closed. And I dropped it in the box, right? Went out
Patty,
on Monday. Yeah.
Patty, I always do personal, what is it called? Personal service but what do you say to, and I make sure I give it directly to the tenant that's on, the rental agreement, but I don't know, not that this is that big of a deal, but is there anything that you say when going to deliver it? Like, oh, here you go. Here's your rent increase. that it?
Hi, how are you doing tonight? You know, it's so not, I always compliment on the weather or on the property. The yard looks really great. Okay, always compliment the weather or the property. Man, it's so hot out here. You could make a grilled cheese sandwich on the sidewalk. Hope you're staying cool. Wanted to talk to you and let you know I have a rent increase for you and to see if you had any repairs that needed to be addressed. Because what comes with a rent increase? A list of repairs that need to be addressed. So I'm going to hit it right there on the head. Wanted to see if you wanted to notify me about any repairs. I have a rent increase notice for you. And personally, I know they go hand in hand. If you raise the rent, they tell you about all the problems at the property. They go hand in hand together. So anytime you're going to do a rent increase, be ready for them to tell you everything that's wrong at the property, because that's what happens. That is human nature. If it doesn't happen, I'd be a little concerned. I'd then be wanting to do a walkthrough inspection to see what they're trying to hide from me. There's both sides of that card. I hope you guys all paid attention. If they don't call me, they don't balk, they pay the rent increase, I need to do an interior inspection. If I was just in there 2 months ago, 3 months ago, 6 months ago, I don't. If I haven't been in there for a year, it's a trigger to go look. My guess is they have unauthorized occupants or are doing something they shouldn't be doing.
Got it. Thank you, Patty. Can you elaborate on that case that you were talking about the people who did the illegal rent increase because they didn't give enough time, and so then they had to pay back the rent? Was it just the rent increase for
It would be the rent increase. But if you pay back a rent increase over 10, 11 years, and then at 10 years you have a new rent increase, you also have to refund all the new rent increases because they're all based on the wrong base rent amount.
Okay.
So basically you have to go back to what the rent was 11 years ago. None of those increases count, and all those rent increases they paid over that time is now showing as a credit on their ledger.
And it won't get taken into, I know this is more of an attorney question, but it won't get taken into account, or will it ever get taken into account if the rent is below market significantly?
No, that is irrelevant.
Okay.
Irrelevant. You know how they look at it? And I'm going to be the biggest ass I could be right now. It's under market value. Well, it's not my fault you didn't manage your property correctly.
So, or it could be looked at, well, shouldn't the landlord get,
Landlord
not
doesn't
praised
get
or
anything.
get a kudos for wanting to, this is a great tenant, I would keep them below. So there's no reason then a tenant should, there's no reason a landlord should ever have their, even if it's a great, awesome tenant who, genuinely have a great relationship with, just keep on raising it. There should.
Absolutely. It's a good business practice. If for nothing else, raise your rent $25 a year. If you don't want to do a rent increase, and you just don't, raise your rent $25 when the time comes. Why? Because it keeps you as a position of the person in the position of power. When you don't raise rent and don't raise rent and don't raise rent, tenants forget and they think they own the place because you haven't reminded them who you are. Okay? So it's how you lose the balance when you don't show them annually, I'm in control here and you are not, because they need to be reminded. I know it sounds ludicrous, but I've watched this happen for decades. Chris, behave. Why do we own investment property? I own investment property because it's extremely lucrative. I know what the rules are and I play along with them nicely. Thank you very much. For properties that were heavily governed by municipalities, I exchanged those into municipalities that didn't have so many restrictions. Val, I want to know how your birthday was. Okay, I have a major problem. Tenant had a plumbing problem. We agreed her portion was $750, which she paid for the massive toilet paper clock. Then my contractor said the old clay pipes were cracked and he had to dig out over 50 feet, 3 feet deep to replace clay to commercial PVC. Just an hour ago, I received his invoice for $15,000. What the? Yeah, I called my insurance guy who says plumbing's not covered. She has renter's insurance, but I read her policy and it does not cover plumbing. Huh. Deep breath, Val. My agent told me plumbing needs a special policy. No, this is tenant-caused damage due to her negligence. Chris, correct me if I'm wrong, but I would be contacting an attorney at this point and going after her for that, and her insurance company for that, because she overflowed the toilet with freaking toilet paper and causes a problem. She's the procuring cause.
Patty, what if she says that, well, it wouldn't have been clogged if the clay wasn't cracked?
That's up for an argument for an attorney to argue in court. But I'd be fighting the insurance company with this as tenant caused damage. It's not our fault the tenant shoved a whole roll of paper towels down the toilet and flushed them.
I don't know. The question becomes what caused the cracks in the clay pipes?
Yeah, was it due to force, due to the tenant's negligence? See how it opens up this whole reason for litigation? I'd be back with an attorney at the tenant's insurance. That's where I'd be headed.
She
But
said
when we
it.
opened up the pipe, we saw it was cracked. There you go. It's all gonna come down to the workman's documentation and what an attorney's willing to argue. But I'd be talking to an attorney about going after the tenant's insurance for negligence. I hope I verbal vomited enough. Linda, didn't the 5-day take effect recently before it was 3-day? I'm not sure what you're talking about. Are we talking about a 3-day notice to pay rent or quit?
Yeah, no, when we gave rent raises, before the 5-day, rate to the 5-day waiting period, it was with 3-day, wasn't it? Like
No,
a
it's
couple
always
years
been
ago.
5 days for mailing has always been California civil process.
Okay, okay, thanks.
No problem. That's what I would do, Val. I missed your question, Arlene. Okay, I'm going backwards. Ding, 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 ding. Oh my goodness, how far back were you? Oh, there you are. So did they get a refund for all rent or just the rent increase? Now week, day, world, their current rent rate. Their current rent, they get a refund for all the increases and all the overages that they paid. And
right, so but
their
the rent today what it was 10 years ago when the
11 years ago, yes. Absolutely correct.
So they could do well, like if it was LAR, so they could do that rent plus 4%, period. And that would be it. Oh my God.
They can't even do the 4% because the first increase they did, so the base rent is illegal. So they have to remove all increases and go back to what the rent was 11 years ago and start there.
Well, that's what I'm saying. Start there and then do a 4% for this year. Or
For this year.
Okay. Yeah.
But
Oh my
no
God.
rent increase for the past 11 years. None. You lose them all.
Wow. Those people are not too happy, are they?
I wanted to throw up in my mouth.
Wait, Patty, and sorry, I'm not the greatest with math, but how would they lose them all? Can't they, if it was, I don't know, let's say $1,000, can't they go based on, and the rent increase was, oh wait, no, hold on. Wait, I'm thinking this, maybe the light bulb's coming on. They lose all of them? Like they can't.
The base rent going forward is wrong on the next rent increase, and so on and so on and so on. They lose them all.
Oh, okay.
The tenants must have been jumping for joy.
Ooh, Val, you got a good question. Should you call your insurance company? I'd call your insurance company and tell them to go after her insurance company.
I had a situation like that, Patty, and I got the renter's insurance to cover, I think they covered about 50%. And then I did it, and then the tenant was responsible, and we did a payout over like 12 months for the
Yeah,
rest of it.
I'd be calling an attorney and asking them to contact the tenant's insurance company, or this might be the least expensive way to go. I'd be contacting your insurance company and telling them that you want to file a claim for the tenant's negligence and you want them to go after, but they're probably going to refer you to an attorney. But try it. Maybe if they get a call from your insurance company, it'll scare the crap out of them. I don't know. I don't know in this instance. I have to really sit and think. But part of me says go to an attorney and have an attorney contact that insurance, the tenant's insurance, and fight that claim. It's not your fault the tenant flushed an elephant down the toilet, right? With an elephant toilet paper. There we go. Also, if you are in the unincorporated LA County under DCBA, check for the current allowable rent increase. Since my rental increase would be effective August 1st, their chart shows I can only increase 1.930 or 2.93% for qualified small property landlords. Correct. DCBA has their own rules. LAHD has their own rules. LARSO has their own rules. Some municipalities have their own rules. Example, Baldwin Park is a maximum of 3% no matter what the CPI is, and it can only be increased by the CPI, never to exceed 3%. That's City of Baldwin Park. It starts with a B. I may be wrong. It's not Brentwood. Baldwin Park. Some municipalities have their own rent increase rules and regulations. So anywhere in LA County, you need to look it up. There's a couple of places you could look it up on stayhousedla.org will tell you how much the rent increase is. You can also look it up under the statewide rent control if that's all that governs you, and you're only governed by the Tenant Protection Act, also known as AB 1482. The easiest way I look that up is Fast Evictions has a tools thing on their website, and it is free and it is most helpful when you're calculating rent increases based on the state's restrictions. I already told the tenant that she would only be responsible for the toilet paper clog, which was $750. But while my guy was fixing, he found the pipes were cracked due to the pressure of her clog. So after review of the plumber's findings, it was found that a further damage was caused by your negligence, totaling the amount of $15,000. We strongly suggest you turn this into your insurance company. Try that.
Kind of depends, again, on whether or not there's any evidence that the tenant's negligence causes cracks, or if those cracks were just like pre-existing or caused by roots, or, you know, I would ask the plumber and ask what the plumber is willing to say for.
Yeah, ask what the plumber is willing to put in writing of what caused that, and then make your decision. Otherwise, I'd be pulling out a HELOC. Don't leverage your finances in the market were forecasted in front of us. I wouldn't put my savings account. I'd leverage the property. That's real talk right there. Leverage your asset. Don't leverage your ass. Sorry. I made it funny. In other words, what is Patty saying? If you got to spend $60,000 to $80,000, $20,000, God knows what, on the property, whether it's to do an eviction, whether it's to do a repair, you may want to consider pulling out a HELOC before you consider wiping out your savings account. That way you use the property to leverage itself and you're still sitting pretty with your savings account. Okay? It's just my thinking is start leveraging your asset instead of your own ass. And that's what I meant by that. Don't put it on a credit card. That's you leveraging your own ass. Leverage your asset and do a HELOC. Something along those lines where you can pull equity out and let the house pay for the repair. Melanie, for a Section 8 tenant, late notice is 30 days, not 3 day. In Larceau. No, that's not true. Hold on, Melanie. Let's answer this question for everybody. Anyone that has any federal funded property, meaning Section 8, VASH, or if the landlord has a mortgage from Freddie Mae, Fannie Mac, I said those backwards. Freddie Mae, Fannie Mac, no, it's Fannie Mae, Freddie Mac. There we go. Fannie Mae, Freddie Mac, and there's one more. I always get those two confused, so forgive me. Fannie, Freddie, what else is there? Fannie Mae, Freddie Mac, there's one more. If you have a federally funded loan, okay, if you purchased FHA and didn't come in conventional, then you have to use the CARES Act notice. And you're absolutely right. It's a 30-day pay rent or quit. And it doesn't count weekends and holidays. It's more like a 45-day notice to pay rent or quit. And that's anything that has Section 8 touching it, VASH touching it, or on the owner's side of lending. They have a Fannie Mae, Freddie Mac loan or FHA. Federally insured.
Patty, they're saying even if you have one tenant out of 100 on Section 8, you have to do CARES Act, period.
In a multifamily building,
Yes.
I would agree with that statement just because, and I'll tell you why they're telling you that, David. This is a new law and there's no case law regarding it. So they're telling you that to err on the side of caution.
Yes, that's true.
They don't know yet. Nobody's argued it enough to find out. Does everybody in the community get a 30-day now? Because everybody isn't paying with Section 8 federal money. Why do all the other people get those protections? Why does the average Joe Blow get that protection if they don't need it? But there's no case law yet. So your attorney is telling you to err on the side of caution for that reason. They don't want you to lose.
Hey, Patty, I have a question for you.
Yes.
It's Christina.
Hi.
So I have the single family home and I converted the garage into the ADU, and I reached out to Livable to figure out how to handle the water bill because the electric and gas are separate, but the water is not. So
Okay.
Livable gave me some options. I have to put in a sub meter, and there's also these companies that offer sub or water sensors. So there's a company called Drizzle X, and they basically their service puts a sensor on every single water source in both units to measure exactly how much water usage is being used when you take a shower, when you flush the toilet, and it's able to detect a leak and where exactly it's coming from because that it's running the water meter all day. So since I'm only under statewide rent control and my tenant in the main house is responsible for her own water bill, so I will basically do the calculation of her water usage based off of the readings from Drizzle X every month. Do I have to give a special notice to her to let her know that I'm going to be implementing this service?
Yes.
Okay. I would like to use it. I just, I'm only under statewide rent control. The Drizzle X was like, I don't know.
I'm with you. I'm with you. Just give me a second. I'm not frozen. Hold on.
Okay.
Widget's Way webinar is not frozen. Patty is frozen. Give me a second. I'm in deep thought. It's as easy as doing sub-metering because that's what you're doing. You're sub-metering off of 1 meter. So
Yes.
just be that this property is subject to sub-metering. Tenants will be responsible for their own metered usage through whatever company you just said.
Okay. But I'm the one who's responsible for the billing. Like they're going to do the metering, but I'm the one who's going to tell her how much water usage she's actually using.
Okay. Are you, so what you're using is still, in my opinion, the RUB system.
Yes.
Okay, so you're using utility ratio billing system. Are you also including the gardener expenses that you incur for this? I mean, this is
Gardener
your,
expenses.
yes. If
What
you're gonna
gardener
use,
expenses would there be? Oh,
if you're dividing up
well, anything that
utilities,
she.
sweetheart, if you're dividing up utility expenses, you can use the RUB system to do all kinds of things. Gardening, if you have a gardener on the property, then both those tenants are now paying half of that, right? There's two people. So you can implement that expense that you're incurring also. What other expenses are you incurring?
Okay, well,
I
I'm
put
gonna
on the
eat.
alarm and I also put on the exterminator.
Listen to Arlene because she's doing this in Larceau, where it is the most. What did you add to it, Arlene?
I have gardener, alarm, exterminator.
There you go.
Okay, typically I'm eating all the costs myself for the ADU because I'm doing like corporate housing in that part. So that's everything but the tenant was originally, when the house was just by herself, she was responsible for all the gardening on her own.
You
And
can leave it that way. Or
okay.
you can now, but I don't like that because now, do you need gardening on the ADU?
No,
Okay, then
there's
leave it.
no,
Then leave it alone.
okay. So
You're not incurring that expense.
do I have to give her a 30-day notice, letting her know that that's going to be implemented, or can I just say as of this date? Because she's moved out, remember? Because she's in an Airbnb while the house is getting repaired. When she moves back, because I'm getting the house repaired from a water damage leak.
I would just ask her to sign a new lease when she comes back with all of the changes that you want to implement.
Okay.
Because she currently is in a term, correct?
Yes, and we just signed an agreement saying that the only thing that happened when she moved out was stating that rental payments were going to be paused and then resumed once the property was repaired.
Okay, so once rental payments are to resume and the property's repaired and the lease is moving forward, that's when I would implement those changes. When does her lease expire?
I'm on month to month with her.
Okay, then I would implement those new rules as soon as she comes back and you're ready to start collecting rent.
Okay, cool.
And the easiest way to do that is to start with a new written rental contract, even if it's a month to month.
Okay.
Okay, that way you're implementing all the new rules as she's coming back.
Okay, before that happens, I'll probably call you to.
That's fine. That's why I'm here.
Okay, thank you.
No problem. Arlene found a new company that does photo management in Inspection Express. Is this somebody that does your walkthrough inspections for you, or does it through the tenant using their cell phone? Because I've seen that too.
They have, I guess they give you a camera and it works with AI also, and it does a 360.
Okay.
And it takes the picture and then it writes notes about everything. Bless you.
Thank you. I was trying to sneeze quietly.
And then apparently when you have work done or repairs done, you can do it then. And then for the move out, it puts all the pictures in. It puts a whole PDF together. It shows the before and after pictures next to each other. It's pretty incredible.
How much do they charge?
It doesn't work for me because I don't have enough doors. So it's like $170-ish a month. But they also have one that's more minor package that doesn't have the AI stuff for like 60 or $70, something like that. Under 80.
Yeah, I got you.
But they did a demo for me. It was pretty impressive. Yeah.
I love those demos. Did you make them buy you lunch? I'm just playing. A Girl Scout.
He's in Australia. He's moving to LA next week. So I almost tried to rent him my vacant unit, but he can't afford it.
That's my girl. That's my girl. Rent that vacant unit.
I'm trying.
Okay.
I think that's something Dan was talking about on one of the webinars.
In regards to
the company she's talking about.
Oh, okay.
Oh,
It may be something new that AGLA's promoting. AGLA tries to stay on the top of innovations for us. Okay, Julia, what do you got? If you're evicting someone not on the rental agreement, like a guest or a squatter, so basically you're paying to do an eviction plus loss of rent, but then it'll never go on their record because you don't have their social security number, correct? Yes, and if you're evicting a squatter, usually you don't do a regular eviction, also known as an unlawful detainer, okay? You do something called a forcible detainer instead of unlawful. Look at it this way, they forced their way in. They were never a tenant, they don't have tenants' rights. It's a forcible detainer, not an unlawful detainer. In that aspect, they lose their argument to cry breach of warranty to provide habitable premises. They lose their argument because they force their way in. Okay. So
Well,
usually when you have a squatter, they do something called a forcible detainer instead of the unlawful detainer.
so how does that differ in terms of the eviction process? Forcible.
It doesn't deter from the process of the eviction. It deters with what they can argue.
Oh,
Make sense?
okay.
If you
Okay, so
can't
then,
argue that you're giving me a shitty house, you can't argue that you're not fixing the property. All of those are eliminated with a forcible detainer. It's not an argument.
oh, okay. So does that mean like paperwork is different and that it's a forcible one or no?
Yes, paperwork that you file with your legal counsel is different.
Okay. And what is it called? You said forcible detainer?
Uh-huh.
Okay.
The
Got it.
other one's called unlawful detainer. So what places you use a forcible detainer as an example is going to be if you have a squatter. Okay. They force their way in. They're not a tenant. That's how I want you to look at it. Forcible.
Or what about a guest?
Hold on a second. The tenant moved out
Yeah, the tenant moved out.
and left the guest.
Yeah.
So you
Essentially.
let the tenant know that you'll be evicting them as the person of record because they didn't give you back a vacant home.
Mm.
And then the person in possession can add themselves to the lawsuit if they choose to, but you tell them you're going to be evicting them and that they better do their damnedest to get that person out of your house because you're
Okay.
coming after them.
Thankfully, this isn't a me issue. I was asking for one of my friends, but they're going with, they actually have this with Fast Evict. So I'm assuming probably Fast Evict would know, how to do all of that.
They'll know exactly what to do. Yes.
Gotcha. Okay, great. And then my other question is, so if you never get the keys back from the tenant that moves out because they don't want to drive them back to you, they don't want to mail them to you, you don't have possession, correct?
Incorrect.
Oh, what do you mean incorrect? I thought you have to get keys in order to get possession.
They could do abandonment or surrender. So surrender is they gave you the keys, right?
Yeah.
If they left you a voicemail saying that they left the keys on the counter, they moved out, did they surrender?
Yes.
They
Well,
tell you
assuming,
they vacated the property, they surrendered.
yeah, assuming, but so all you have to have is them like a voicemail saying or something in writing saying that they've left. But even if you don't have the keys, I thought you have to have the keys in order to.
If you show up at the property and nobody's there, that's abandonment.
Okay. So if they say, like they left you a voicemail, but they're
Bingo.
saying
You got an email. We vacated over the weekend. Thank you. You have possession.
No keys though. They didn't
Doesn't
leave
matter.
the keys.
You have possession. That's a surrender. And they
Oh,
did it in writing.
Oh, okay. I thought the
They didn't
surrender was
surrender
the
you the
keys.
keys. They surrendered you the unit.
Oh, okay. Gotcha. Okay.
Okay.
And so if you don't have any of that, then that's when it goes to the abandonment where you have to post the abandonment form.
I would be posting the notice of abandonment of personal property for anything that they left behind regardless.
Oh, okay. And what is that, 14 days? You have to put that up for, or how long is it?
18 days. I had to think about it.
Okay, got it. Thank you.
Just so you know, that quick pause was I saw the document in my head and read through it. No, it's 18 days. Okay, Tony, I have a low-income tenant whose rent was being paid by LA Global Care from Long Beach. They stopped paying the rent. I was finally informed that they had cuts due to the Trump administration. Of course, they're blaming Trump for everything. God love him. But was assured they will be paying all the rents once they got funds. Last week, they paid April's rent without the late fee of 6%. This tenant's on a month-to-month and has not been able to pay her utility portion and has no renter's insurance. She got sick and now is on an oxygen tank. How should I tackle this? LA Global Care does not answer my calls or emails because they don't have any more funding and they're done. And the chances of them getting more funding are slim and none. Start eviction, non-payment of rent. This is business. Let me say it to you a different way, okay? If I lived in your house and I didn't pay you since April, you'd be evicting me, yes? Same concept. And if you wouldn't be evicting me, give me the address so I'm moving in. I'm kidding. This is business.
So
If
there
they
are no
can't pay you
ADA
in the...
protection.
Go ahead.
Patty?
What?
No, there are no special ADA protections or anything like that for somebody who is disabled.
Yes, but do you want to know where that protection kicks in?
Where?
At the sheriff lockout, when they ask for additional time because of their disability. And you have to allow that. But now the sheriff's involved and won't let them take longer than 10 days, 30 days, and gets them the resources they need.
I see. Oh,
So
that's
if you
interesting.
play up at front and try to sugarcoat it, all it's doing is costing you time and money. You're gonna have to give them the additional time at the sheriff lockout. So just start the process, because that's how it works. I had someone I had to evict. Don't judge, okay? This is business, okay? You got to remember that. Take your emotions out of it. This is business. I had somebody that I had to evict that was bedridden. Bedridden. Sheriff shows up and says, I can't kick them out today. I said, I know you can't. He goes, I'm going to have to call Adult Protective Services, have them. I'm like, I know what you have to do. Now the sheriff is calling Adult Protective Services and telling them to jump. So Adult Protective Services is helping relocate them as quickly as possible. And then the sheriff says, I'll be back in 10 days to do the lockout. And then they call you and say, okay, we're going to go try again. Let's see if this works this time. Usually they get it on the first try. Sometimes it takes them a little bit longer. The most I've seen that go, honestly, has been 30 days, maybe. It's not as bad as you think. Okay? So stop being afraid because somebody has a disability at hello. Where they need the assistance, it will be given to them. Okay? And I'll tell you, when the sheriff calls Adult Protective Services, things happen quickly, faster than you and I can make it go. I hope that helps you. We have to do good business. If we continually make loopholes for people and because we're afraid, we're only hurting ourselves. It doesn't matter that that program ran out of money. I hate to tell you guys this, but eyes wide open. Pay attention to what I'm saying because it makes sense. Okay? In the past 5 years, if I say something that isn't right, somebody in there correct me. In the past 5 years, we've seen Section 8 housing pay the full amount of tenants' rent, and then gradually, over the past 5 years, we've seen them decrease what they pay and make the tenant responsible for more to the tune of half to 3/4 of the rent. Section 8 used to pay everything but $12, everything but $100. Not anymore. They only pay a couple $100 towards the tenant's portion. Okay? I wouldn't be shocked by the end of the year if Section 8 has no more money in their budget. I think that Section 8 has been gearing up for this for quite some time in lowering the amounts that they pay tenants, making them responsible to pay more, trying to prepare them for this. They've known this is going to be happening. But blame whoever's in charge, right? That makes the most sense. No, this has been going on for years. And not one person corrected me because now that I'm saying it, it makes sense to them. That's exactly what's happening. Section 8 has been weaning tenants off of the program for the past 5 years. Oh, my guess is within the next year, they won't have a program anymore. Who knows? It's getting scary. Can this tenant claim habitability issues if evicted since she's been smoking inside and I saw that the walls had yellowish residue? I asked a remediation company how much to clean a smoker's unit, which is a breach of the rental, and they said it'll be about $5,000. If they had renter's insurance, would it cover it as tenant caused damage? Potentially, especially if your lease contract said no smoking. But it all depends on what your lease says. And $5,000 for smoke damage? Yeehaw, jump on that, because I've had to replace carpet, padding, have the AC ducts cleared out. I've had to have drywall replaced in some instances where the drywall wicked up the freaking smell, because you have to worry about secondhand smoke and third-hand smoke now. So if they only want to charge you $500 to make that all go away, make sure you get something in writing saying that they've removed all of the tobacco residue. And ask them about third-hand smoke. Tenant can always claim habitability issues if they're evicted. As far as damage they caused, how could damage they caused be a habitability issue for you? Well, let somebody argue it, right? You never know. Just plain. Just plain. Okay, so today we talked about rent increases and to make sure that we're doing more than a 30-day notice. It's a micro unit. I gave them the square footage of 205 square feet. They said they would have to use an ozone repaint. And if there's AC vent, if there's ducting, they got to do that. Sometimes painting doesn't get rid of it. Ask them about third-hand smoke. And are they giving you a certificate in regards to that? So just so you guys understand what third-hand smoke is exactly what you're talking about here. Is where you have tobacco residue somewhere, okay? 10 years from now, you can still smell that tobacco residue because it's still emitting carcinogens. That's third-hand smoke. It can emanate years from now and cause someone damage. Yeah, all that's going to have to be cleaned out. And you want some kind of certification regarding third-hand smoke. Because third-hand smoke damage is real and you'll get sued for it. We all understand what secondhand smoke is, right? Somebody's exhaling and that stuff is going through AC ducts and neighboring units. Third-hand smoke means that it's already there and it's still emitting the smell. Nobody's actively smoking. Second and third-hand smoke affects a lot of pregnant women. Just saying. So far, I don't know of any pregnant men that it's affected. Sorry, I was trying to be politically correct. I had to. Nobody laughed with me? Nobody? I thought it was funny. Okay.
I'm laughing.
Okay, good. I just want somebody to giggle.
Patti, I have a question.
I'm with you.
Somebody has a question. Go ahead.
Yes. If you have a building and you don't have anything like non-smoking, everybody can smoke here, there, everywhere inside the building. And then a neighbor complains that in my unit next door is smoking too much. And am I supposed to say, okay, you can move out, make a decision or stay, it's up to you. But am I being responsible? Can I be sued later for that?
Nothing says that you have to provide a smoke-free building. Okay. So what I would tell them is, we allow smoking here. If that's a problem, I'd be more than happy to let you out of your contract.
Yeah, something like that. I did say, okay. Thank you, Patti.
That would be the verbiage I chose. Because maybe they didn't know, maybe they didn't realize. So you don't want to hold their foot to the fire because they didn't know. But if they think you're going to control how much or what someone else is smoking, they're sadly mistaken, because you can't.
Actually, I've offered them to move him to another unit. Is that acceptable?
Is it in the same community?
Yes.
Who's to say they're not going to have the same problem?
Well, we know the tenants who's who, and some smoke, some don't.
I get you. So you can give them that as an alternative and see if they're open to that, to try to accommodate them. But I wouldn't bend over backwards.
Thank you, Patti.
No problem. Thank you, David. I had a tenant, this is Val. I had a tenant in Kern that was complaining of unidentified invisible pests. We couldn't get an exterminator out until yesterday due to the holiday. They charged $250 and identified carpet beetles. Okay, that's really freaking gross right now, and I'm so glad I don't have carpet in my house, because I'm getting the heebie-jeebies, but I don't have carpet anywhere, so I don't know why I'm getting the heebie-jeebies. Okay, I stopped. There is only a small amount of carpet in the one-bedroom house, one bedroom. He says he is clean. Now that is in doubt, but since I paid for the first eradication of $250, what would the tenant need to pay in the future if the problem persists? Ask the exterminator for a source of infestation. How did they get carpet beetles? Ask them for a cause of infestation and a cleanliness report. Val, you little shit. There's not a carpet beetle on my shoulder. I'm not even going to turn around. She knows how I am when I teach bedbug classes and I'm standing up there doing this in front of everybody because they give me the heebie-jeebies. And people tell me they're bedbugs, not head lice, and I'm like, I don't care. Stop it. Behave. You behave. I'll behave. You behave. Anybody have anything else? I have a busy day. Guess where I'm going Friday? My grandson's visiting, so we're gonna go see my sister and play in the mountains. I promised him I'd take him fishing. So I'm gonna take him fishing this weekend. That's what I'm doing. Val, stop it. When you first said he had carpet beetles, I thought you were trying to tell me about a STD and be like appropriate or politically correct. That's why I stopped dead in my tracks, is because I was waiting carpet beetles. I've never heard of such a thing. And then I thought maybe you were referring to an STD. Oh, I'm glad we're all laughing here. Thank you, Val.
Patti, I had a question in regard to the 5, you know how you have to, if you're doing certified for the rent increase, you have to give more than 5 days, or sorry, you have to give 5 days in addition to the 30 days. Is there, what about for Section 8? And what if they've been there longer than a year? Is it like more time?
On a rent increase?
Yes.
Okay, deep breath. You're crossing up terminating tenancy and a rent increase. So let's just talk about a rent increase, straightforward, okay? 10% or less is a 30-day notice. Anything over 10% requires a 90-day notice. Anything federally funded requires a 90-day notice.
Okay.
So Section 8 is 90 days, right? VASH is 90 days. Anything over 10% is 90 days. 10% or less is 30 days, unless it's Section 8.
Yeah, I've never done anything over 10%, and all my non-Section 8 tenants have all been 90-day notice. So
Right.
does that mean for a Section 8. The only one that is popping into my head is the Section 8 one where I'm like, oh, so does that mean I have to do 95 days?
Yes, I'd rather have you do 95 days if you're mailing and not personally serving. You gotta add the 5 days for mailing.
Yeah, so now I personally serve. In the past, if I didn't do 95 days and it was, I don't know, 92 days or something.
Then your rent increase is illegal, and any rent increase after that is invalid.
So then how do I remedy this?
Credit on the ledger.
Okay. Got it. Okay. Thank you.
No problem. Val, that's why I asked for cause of infestation. If carpet beetles, and I don't know anything about them, don't know what they do, how they are contracted. I don't know. Are they like head lice and they only go in carpet? And if so, how did those carpet beetles get into your property? Right? Did they come from the manufacturer? I've never heard of them. Carpet beetles. Are you sure you're not talking about a sexually transmitted disease? It's like, I believe the price gouging for Newsom has expired, but look up state of emergency in California. You can look them up. There's a website that keeps track of them and when they expire. I believe, just Google state of emergency in California, and it'll give you where the states of emergency are, what they're for, and how long they're inactive or how long they're active. And remember, if you're worried about the price gouging law, Sydney, that's California Penal Code 396, paragraph B specifically talks about rental housing. And you don't want any state of emergency in the expiration of the notice period either. So, example, you're doing a 90-day notice of rent increase because you're going over 10%. In that 90 days, we don't want to have a state of emergency.
No, in my case, the tenant has moved out. I'm remodeling the unit, so I'll be getting a new tenant in, and I want to be able to charge more than what I was charging before. So
We don't have any vacancy decontrol anywhere in the state of California at this time, so you should be able to bring it up to market rent. And I believe that expired on July 1st.
Okay.
Does that help you?
What if I want to bring it to above market rent?
Put it on the market. We don't have vacancy
Let's see.
decontrol.
Okay. So I was just making sure that was done.
I got you. Okay. List it, baby.
And when it's ready. Okay, thank you.
The time is now.
I know.
And then I don't know if you guys know this. I deal with all kinds of people, attorneys, lenders, you name it. Okay. I had some lenders contact me earlier this weekend and the end of last week, just panicking. Patti, I'm trying to do these loans for people and I can't get them because all of a sudden they have a notice of default on their credit. Well, Patti, what's going on? Let me explain something to you folks. Pay attention. I may ask questions later. Banks run on a fiscal calendar that expires on June 30th, and they start their new fiscal year on July 1st. So they end their year on June 30th. Banks do. Banks, lending institutions. So they don't want to tell their investors about all the people that aren't paying their mortgage. Okay? The investors find out when they file the notice of default. So what did all these banks do? They didn't file the notices of default until July 1st. That way they didn't have to tell their investors that all these people are behind in their payment. Boom, July 1st hits and all these notices of default are filed. Because now the banks are going to be coming. Okay? Let's see how many people can pull themselves out of default. And how many people can't. Because that trigger we've been waiting for, now that the banks close their fiscal year, we may see a lot more of activity. We may see a lot more foreclosures coming to light. Buckle up. Okay?
Patti,
Yes.
with Julia's question with the Section 8 having to do the 90-day, but my one tenant in the building, then all of them have to get the 90-day, even if they're not Section 8.
For LARSO?
No, not specifically. I think just any Section 8. If there's any Section 8 in the building, then the whole building gets the same regulations, is my understanding. That's what I've been hearing.
Because there's no case law. They're
Maybe.
trying to get you to err on the side of caution. I don't agree with that. But there's no case law yet arguing the CARES Act. And that's what we're talking about. Why on God's green earth would any one of us own an apartment community if we had to treat everybody under the federal laws with all the protections? It's not fair for me to wait 45 days for a tenant to pay their rent. And we're talking about Section 8's portion. It's a 45-day notice to pay the $200 portion. It's all bullshit. Sorry. Let me say it a different way. It's a way to handhold the gimmies. That is the most ludicrous thing I've ever heard of, but I get why they're trying to err everybody on the side of caution. But geez, watch how quickly I don't want to comply with Section 8 because I don't want to allow that in my building. Remember, none of us can say that we don't accept Section 8. It is illegal. It is a violation of the civil rights and discrimination against source of income. But you can, as a landlord at this time, unless a municipality tells you you can't, say that you only want a month-to-month contract and you're not interested in a term for time. Unless the city that the property resides in requires a 1-year contract, that is a reason that you can say, we don't do 1-year contracts. We only do a month-to-month. Some municipalities require a 1-year contract at hello. I believe City of Santa Monica is one of them. I believe LARSO is one of them. Anything RSO is one of them.
West Hollywood.
West Hollywood, the Wicked Witch of the West is how I remember which Hollywood's the worst. Wicked Witch of the West, got it? So there's few municipalities out there that require a 1-year contract at hello. If you're not in that municipality, then you're not interested in a term for time. Why? Because Section 8 won't participate with your house if you won't give the tenant a 1-year lease. You don't know if you want to sell. You might be getting a divorce. You don't know. So you're not interested in a term for time, but thanks for inquiring.
Patti, so what if they will ever, like Section 8 ever do just month to month?
Yes, after the 1-year contract is complete, it goes to a month to month.
It goes to month to month. Okay.
Julia, what is Patti trying to say? You can't say we don't accept Section 8.
Yeah.
But you can say we only accept, we're only doing month-to-month contracts. We're not interested in a term for time. And that Section 8 worker will work you, trying to convince you why you should do the term for time. Stand your ground.
Got it. Thank you. For that Section 8 one that they made too much money, so they got no longer Section 8. They graduated from the program.
And then the person passed away and they're
yes,
have to go
the
back on.
spouse passed away. So I just added them back into the Section 8 program, and without having to do, because I was very concerned that I was going to have to do a 1-year lease, which I don't ever do a 1-year lease.
They just
they just put it back into the system, which I mean, I'm technically fine with. I haven't had a problem with it, but I just didn't know how that was going to unfold. So that's kind of
hey, that's on their end of the fence, not on ours.
Okay, got it. Thank you.
No problem. Does anybody have anything else for me? I'm like, please, somebody have something for me because I don't want to do my project I got to do when I get off of here. No, nobody's going to save me today. Okay, I'll go back to my work. All right, you guys, if you need anything, let me know. I will be available via telephone as always. We have a live and in person with AGLA on the 30th of this month, 30th of July. I believe it's a class on notices. I'm going to be talking about, I think I'm going to, oh, I'll see you there. I'm excited, Christina. I love it when you guys show up there. But I will be there live and in person. I try to let go a lot out of my arsenal at the in-person events for you guys. I let a lot more go because I can see your faces and I'm not afraid that you're gonna use my words against me. I am worried since I verbally told tenant I would pay for the extra plumbing issue, I may be held to that. Val, you had no idea that the extra plumbing issue was so extensive due to their negligence. I keep giving you the verbiage. I had no idea that the additional plumbing expense was so invasive. Expensive, invasive, use it all. Okay, Tony, I got you. Tony. I already did a rent increase to the low-income tenant effective August 1st. If I evict for non-payment of rent for May, June, and July's rents, can they claim something against me like retaliation? No. Look at it this way. You did a rent increase to take effect in August and your 3-day notice doesn't show August rent. So, no. They could say that you tried to retaliate. What? I raised the rent and I'm not getting any. I raise the rent every year in August. It's just what I do. It's not retaliatory. No. That's when the CPI changes, right? And girl, if they want to cry retaliation, they're going to say anything that you said or did or even tried to do nice, they're going to flip and try to use against you. Don't walk on eggshells, okay? Just treat them the way that you would want to be treated. Even though the work has been done, can I still give this tenant a 60-day notice to vacate due to extensive renovations? Val, is this a duplex or a single-family home? If I remember correctly, it's a duplex and you need just cause. Not exactly, but it has a detached unit in back.
I thought the law changed. Now you cannot evict somebody because you want to do renovation.
Correct. You can't evict somebody for renovations in LA City and LA County.
Oh, I see. Okay.
They didn't pass that across on a statewide.
Oh, okay.
But the reality is it's not major renovations. And here, how long did it take to get the repair done? And, see, I would be more against, no, you either, I would serve a 60-day notice and then we have to give a cause. And I'm trying to think of what the cause would be. And you'd have to pay relocation fees. See what the plumber says, Val, because I have some ideas, okay? See what the plumber says. See what the plumber says on what the cause was. Why did the pipes cracked? Get it in writing, and then I'll help you better, because then I'll know what angle we can argue and what we can't. When I call you Patti for something specific.
Oh, sorry, Patti. Clearly I can't type. I'm having a lot of typos today. No, when can I call you?
I didn't even read that the way that you wrote
Oh.
it. So.
Okay, I'm glad it wasn't me because the first time it was a me typo, and then I'm like, wow, did I make another typo again?
No.
But yeah, I have something kind of
Just
specific.
call me when the webinar's done. I'm totally fine
Okay.
with that.
Okay, thanks.
And if we stay on here long enough people will get off, and then you'll be like, oh, it's just you and me. No, I'm kidding. That happens too. All right. Anybody else have anything for me? Otherwise, I am going to go start my project with my grandson. Wish me luck. If you guys need me, you have me. Feel free to call me. I'm here for you. Watch your rent increase notices. Add 15 days to them. Err on the side of caution. In other words, don't send it on the 30th for it to take effect on the 1st of the following month. You're not giving yourself any cushion. Give yourself some cushion. Okay? I know we always want a rent increase to take effect on the 1st, so raise it any day of the month you want to take effect on the 1st of the following month. Give them 45 days notice.
Thanks, Patty.
No problem. And Julia, I don't know if you caught me in there, but when we were talking about rent increase notices, I never once mentioned a 60-day notice of rent increase because we lost it in 2020. It doesn't exist anymore. No more 60-day rent increase notice.
So you said we lost it in 2020. So before 2020, because now I'm looking through my.
You could have done a
binder.
60-day notice of rent increase for anything over 10%. 90 days was required for Section 8. But in 2020, they got rid of the 60-day notice of rent increase, and it's either a 30-day for less than 10% or a 90-day for Section 8 or anything over 10%.
Okay, got it. Thank you.
No problem. I just thought I'd throw that fact so that you'd know, why do I have a 60-day rent increase? There's no such thing. Yes, there was. Yes, there was. It ended in 2020 or 2021. I'd have to go back and look at statute. And now that I see it in my head, it didn't come out the same time as COVID. So, I mean, as AB 1482. AB 1482. No, it came out the year after. So I want to say it happened in 2021, January 1st. It's disgusting now how I anchor most of going back through the Rolodex in my brain as COVID coming out and AB 1482, because AB 1482 came out and COVID hit 3 months later. So we had a lot of things happen with AB 1482 and COVID. A lot. All right, you guys, I'm going to get off of here and start my project. Wish me luck. If you guys need me, hunt me down. Julia, feel free to give me a call. I am available. Bye, everybody. Have a great weekend.
Have an awesome weekend. Thank you.
Bye.
Thank you.